Well,
So
that,
I think it's. I think in some sense it's dated to think it's that hard. And it's related to what Con was saying, is because if you look at hedge funds who are very different, it's hard maybe for a union or CalPERS because they don't want to expend their own resources to do this. But there's been several studies of hedge fund activism by Brav and Co. offers Klein and Zor, and you find an extremely high percentage of success of hedge funds in electing people to the board and their other proposals. If you were to look at sort of, and so that's one sort of thing we have to understand, the sort of dynamics have changed, just like sort of the concerns about defensive taxes and poison pills. They're irrelevant for how hedge funds act because they're not trying to get big blocks of stock that a poison pill prevents. So they've had fair success. Now, they're not going to cover every firm. And so they're only looking at certain firms. It may be it's hard to replace them in some sense because not every firm needs management to be replaced. But we have a different dynamic in the current marketplace. And the other thing that's raised upon this, and I guess both of the previous speakers have mentioned it, this is a cost issue about who's going to bear the cost of a proxy fight. And so there's two, I'll just make 2 points about this. One is that we've gone down the path now to proxy access. An alternative would be, instead of going this route, which is going to say, okay, management's proxy will contain an individual share as one, two managers because they're not seeking control, and control is for this. It's very artificial to sort of say influence and control, and we should, if we want to replace them, we do want to have influence. Well, maybe we should be thinking instead about making it, thinking about more of the use of electronic proxies rather than mailings or writings to make it sort of even more inexpensive. There have been a few, at least one proxy fight that I guess a hedge fund engaged in, which they didn't go through the mailing route, because in many firms there's only like 50 institutions that hold the block of the stock that will get you enough votes. And so those people you can call on the phone, you can use electronic means, just don't solicit everyone. Now, maybe this is, would be a concern that, oh, I'm a little investor and I'm not getting it in the mail, so I don't know what's going on. And that might be some aspect if you thought they vote differently from the institutions. But they're the ones who are most involved in this anyway. So there's another sort of way to think about that. And the other point we want to make is, well, it's not bad to make people bear the costs of doing a proxy fight. So there, sometimes the old adages that we have some truth to them, like saying it's good to make people put their money where their mouth is, or to have skin in the game. And I think if you look at sort of some of this, that's the whole point about the proxy fight. You have to expend your resources. If you look at the what we refer to as an event study literature that says what's the stock price reaction to a particular corporate event, proxy fights have big positive effects, whether or not actually the challengers win, and that's because since they have to spend money, they're going to be targeting firms where they think changing the board or putting their policies into play is going to have an impact. If we look at the shareholder proposals that come under the 14A8 regime, which is what the proxy access is going to expand to include elections, now they don't, but there are things like let's change the governance, let's get rid of a defensive tactic, change the board and the like. The event study reactions to these are insignificant. And part of that is because we can give many reasons, and it might be, well, they're not going to pass, but some of them now pass, and the defensive ones, and they still are not getting stock price reactions. We can say, well, management will ignore them, but actually, over time, management actually adopts, gets rid of staggered boards when they succeed. And so the argument I would make is why they're insignificant is because people put up things that may have no value effect because they don't have to pay for it. So they just put it up. If it succeeds, it does. And so I think that's really what the issue with proxy access is. It's good to have people have some financial stake. At state law, if you succeed, you can get yourself reimbursed. And actually the biggest issue, I guess, or one thing that may sort of make it less important to have access is, we have now a Delaware statute allowing you to put in your bylaws to pay people's proxy expenses. Right? And so to the extent that if we put them in, so it's like overturning that case, which it wasn't clear, in Computer Associates, can you actually do something about this and say we want to pay people's expenses? You can make it clear, and that would be another way to reduce the cost, but they have to succeed in some sense. So they put their resources in, and I think that's sort of a way to be thinking about that. Now, that's not to say whether, this would be good even from the director-centric point of view that Steve is saying, but I think that's a somewhat another way to think about what's going on here and whether we have to worry about are people going to be are not getting able to change the director, so we have to make it free and just put one up as opposed to actually trying to change control at a cheaper but still your own cost. All right. Well, Mr. Katz, yeah, you launched this great debate, so let me give you a chance to close it.
I think that
the issues that all of the speakers have raised are very, very important issues. But the bottom line is what shareholder access through the proxy statement does is it will turn into a focus much more on special interests because people don't have to put money behind what they're doing. I mean, the actual cost of running a proxy contest today, with the changes with electronic proxy statements being in existence, is really the cost of writing the proxy statement, which is probably $50,000 to $75,000. If you're going to solicit and have ads or do other things or do a bunch of mailings, there's a cost to that. But the answer really is that in many companies, especially the larger ones, if you call 20 investors, you'll get 50% of the capital. And you know, in some companies it may be 100, but most of that information is publicly available, and it's relatively easy to find support if you've got a good proposal or a good slate. Historically, what happened is people would only be able to elect a full slate and basically get control of the board. The SEC in the early 90s changed that and allowed this concept of short slates. And in fact, it's that short slate that has empowered people to and had a willingness for the institutional investors to elect people to boards, even though they weren't getting control of the board. And frankly, what we've seen is when raiders have come in and sought control of the board but really didn't have a better story than the management that was already in place, if they sought control, they would lose. If they sought a say on the board, but through the short slate process, generally they win. And the numbers, frankly, that Professor Romano was alluding to are actually underreport the success of hedge funds, because in most cases, when a company is, especially in this environment, when a company is facing a proxy contest or facing costs that it finds distracting, it actually will settle out and put somebody on the board on their own. And I'm not saying that that's a good thing, but it's a way that companies respond because they don't want to go through the cost of having a proxy contest. So the bottom line is, I think there's a real cost to a proxy contest. It's a cost on the corporation. It's not just the dollars out of pocket, it's the distraction and it's everything else. But I think that a limited number of proxy contests is a good thing. If you broaden it through shareholder access, and even though it's not control of the board, and you empower special interest groups to put forward their own directors, and at least the current proposal, it's a first come, first serve system. So it's not necessarily the largest shareholders that will get the say, it's the person who gets the proposal in first that meets the standards. We're going to be catering much more towards special interests, and it's going to be both a distraction and it's going to take away from the longer term perspective that the corporation should have.
Thank you. One quick wrap-up.
Yeah, I'd like to pick up on a couple of points of the speakers. We talked about hedge fund activism as well as sort of union fund and pension fund activism, and there's some important differences. I mean, I certainly will agree that the hedge funds have been successful, but they have a somewhat different model that is not universally popular, which is they can take a position in a company, can try to do whatever they want to do. They are accused of short-termism, and if they don't like what the company is doing, they can get out. Now, by contrast, the union funds and the pension funds have many indexed holdings. They can't get out. They can't walk away from a particular investment in many respects. And that is what I think has led to some of the activism, because the only way to try to enhance long-term value at the individual portfolio companies is by raising questions of governance with the companies, because you're stuck with them for a very long time. In terms of proxy contests and the like, it's correct, there have not been that many. And I've actually worked on some for some investor groups in the last 10 or so years. The real problem is that to win a proxy contest, you can't beat somebody with nobody. And as David indicated, if you want to get a seat on the board, you need a good story to tell, and it can't be the current guys are a bunch of jerks who have run the company into the ground. The question is, what will you do better? Given that dynamic and reality, I would seriously question the idea that special interests would somehow control the process. Investors will look to see what a nominee will do, and if 51% of the stockholders who are voting say, we want this person on the board, I don't think that's how you can say this will just be a special interest candidate, particularly when the director will have fiduciary duties and various other obligations. If that's what the shareholders want, what's wrong with the picture?